Welcome to another San Diego County Medical Society webinar. I'm Paul Hedgie, CEO of the Medical Society, and I want to thank you for joining us. We started this program in July last year, started up our webinar and CME programs. And they've been very popular so far. We've got a lot more participation from members and physicians in our community than we've had in the past. We're planning to continue these at least on a monthly basis. And I invite you to send us requests and suggestions for different topics. I'll be meeting with the Medical Society Executive Committee in a few weeks, and we're going to pencil out the next 2 months of programming. And so if you have anything that you're particularly interested in, please send that in. You can email us at sdcms@sdcms.org. So the Medical Society at themedicalsociety.org. Please send in any of those suggestions. We'll see what we can do. We already have a program scheduled for next month on long COVID. It's going to be an extended 4-hour training expected to be approved for up to 4 CME on a Saturday, and bringing together a lot of the local experts on long COVID with different system specialists coming in on that. So look for that. I think we just sent an email out about the other day, and we'll have more information coming forward. With that, I want to thank the Doctors Company and Carlson and I think it's Chaperone for putting this program together for us. And I'm going to pass the torch to Kathleen Sowell at the Doctors Company.
Thank you, Paul, and thank you, Jen. Welcome and Happy New Year. This is our first program of the year, and we're really excited that you were interested in this topic. But first, on behalf of the Doctors Company and Rich Cahill and myself, we want to thank you and acknowledge you for being out there on the front lines. COVID continues. We're now in year 3. You've worked all day, but you still showed up tonight. So thank you for that. This program will be recorded. And if you want to listen to the recording at the end, we will tell you how you can get the recording to listen to this. I want to remind you that if you want CME credit, the slide that you're looking at right now, you can, if you have a smartphone, you can turn your camera on and point it at the QR code in the center of the page, and it will take you, and it'll say go to the Doctors Company I/O. That's our online system. And you will then see the screen in number 2 on the front of that phone, where you will enter your name and your license. Your license is MD, DO. If you are a PA or an NP, you can, of course, get credit through the nursing board and the Department of Consumer Affairs. And if you are a dentist, we also are giving dental continuing education units. You'll check in, and at the end of the session, the program ends at 7:30. The evaluation will come up on your phone, and you can complete that, and then your CME certificate will be sent to you at the email address you put on your check-in. Our topic tonight is how to avoid being reported to the medical board. And I want to very quickly tell you why we're even talking about this. COVID has unleashed a whole new breed of issues and problems well beyond the health issues and the mental health issues. And that is people who are just upset, angry. And so we've seen a huge escalation of grievances filed against physicians to health plans, and also complaints to the medical board. This is our disclosure that none of the speakers tonight have any conflict of interest. The program objectives tonight are to help you understand the medical board's role in consumer complaint management. We're going to look at 3 frequent reasons physicians receive a letter from the medical board, help you evaluate your practice to see if there's something that you can improve to decrease the chance of a medical board inquiry, and also recognize a brand new CME standard that took effect January 1 that requires all CME programs to include cultural linguistic competency and intrinsic bias content. I am the Senior Patient Safety Risk Manager for the Doctors Company. I'm not going to read all of these. I'm sorry, my phone went off. The bios, but they are in the slides, and you also will have access to the slides. With us tonight is Rich Cahill, our Vice President and Associate General Counsel, has a very illustrious career in malpractice and legal services, and he is going to share very important information regarding legal implications of board reporting. We also have from the law firm of Carlson and Jayakumar, one of the founding partners, Keith Carlson, who is also an endorsed business partner with the San Diego Medical Society. The group is also an endorsed business partner with Orange County Medical Association and with Los Angeles County Medical Association. So whenever I'm looking to refer someone who needs help for something that's not malpractice related, I'm happy that this firm is available to provide service to our groups. Joining Keith tonight is Lil DeCampo. She is also a partner at Carlson and Jayakumar, and she has extraordinary experience and background. Both of these attorneys do, and their detailed bios are included in the slides. I'm going to start with an 1814 proverb. It was this long ago that someone said, "A man who is his own lawyer has a fool for a client." Well, I don't know who said it, but you're going to see tonight, you don't ever want to act on your own behalf with the medical board if you get an inquiry. That's the takeaway. The board has the power to take away a doctor's license if it decides that the person has acted inappropriately. And by the way, anyone can file a misconduct complaint with the board, and every single complaint must be investigated by the board staff. And that was something that Jerry Brown established when he came in as governor a number of years ago. And fiscal year 2019 to 2020, the medical board reported 10,868 complaints against physicians. Those complaints related to drugs, alcohol, sexual misconduct as the fastest growing allegations against physicians. So you're going to hear tonight about the precautions you're going to want to take. Sometimes it's something that you say, or that something you don't say, or it could be a look or a touch. So you want to be very mindful of the patient's perception of what's going on. The medical board investigation, I guarantee you, will change your life. If it's for unprofessional conduct, it's very unsettling because your license is your life. That's how you make your money. That's how you run your business. And to think that there could be any threat or any kind of sanction or any kind of probation on your license can be very much put your practice in jeopardy. In fact, if you're on probation, you have to notify the health plans. Many health plans will not reimburse for physicians who are on probation. Unprofessional conduct includes breach of confidence, record alteration, fraudulent insurance claims, and that's a very fast growing problem. Misleading advertising, where websites overpromise and have information that's not entirely accurate. And if you get a DUI or you get arrested, you're going to hear tonight, you have to report that to the medical board. You need to self-report because the police will report it. And if you didn't report it and they get the report on you from the medical board, that's going to be not good for you. Office practice issues also generate a lot of complaints to the medical board. We see it most with failure to provide medical records when they're requested. There's very specific federal and state rules about HIPAA, how you provide rules. Wrongful patient termination results in reports to the medical board and grievances. And we're not going to talk a lot about patient termination tonight, but that's a very common reason people complain. They retaliate that you dismissed them, so they file a complaint. A doctor who says, "I won't sign a death certificate," that becomes an increasing problem. And then patient abandonment, where the patient says, "You wouldn't see me, you wouldn't make an appointment." I'm not going to read everything on this slide, but I want to just point out a couple of things that are in the news, because there's a lot in the news. California University reached a $73 million settlement with 7 women related to sexual abuse of patients in a student health center. A California physician was arrested on allegations he physically forced himself on a patient, ignored her rejections, he held her down and kissed her. And a California surgeon was accused of sexual misconduct. And they go on. Medical board responsibilities are in 4 primary categories. a complaint unit, an investigation unit, a disciplinary action unit, probation monitoring unit. And who do they investigate complaints about? Medical doctors. That DOs do not get investigated by the medical board. The DO medical board does that. Licensed midwives, polysomnographic trainees, technicians, and technologists, and research psychoanalysts. But tonight we're primarily talking about physicians. To consumers, the board has no jurisdiction over billing fees and disputes. They get a fair number of complaints that I'm trying to get information about my bill and the doctor's office won't provide it. And they will generate a letter saying that this patient is requesting information, but they're not involved in office policies, appointment times, personal conflicts, unless the behavior seems to interfere with the safe delivery of health care. And they always tell the patients to contact their insurance company or the individual healthcare provider to resolve general billing or fee disputes. I want to show you a snapshot of the medical board website. If you put in California Medical Board, this is what comes up. And I want you to see on the right side, I put the right arrow in there just to bring your attention to it. And it says file a complaint. Learn more about the complaint review process and how to file a complaint. This is how easy it is. A patient just clicks on file complaint. The next page that shows up is this page. And it says, do you want to verify a license or file a complaint? You put file a complaint. Now look what you get. This is what the consumer will see. Please check the box which describes the nature of your complaint and provide details on the next page. Substandard care, prescribing issues, sexual misconduct, unprofessional conduct, office practice issues, which include failure to provide records, abandonment, death certificate when signed, unlicensed provider, aiding or abetting an unlicensed practice, and then what's called physician or provider impairment, where the patient is complaining that they think that you smelled like alcohol or that the physician was inappropriate in some way that could reflect in some mental or physical type of impairment. This is how easy. And then you have the catch-all other. This is how simple it is for patients. And you're going to hear tonight, especially from Keith and Lil, about the sexual misconduct issues. Disciplinary actions against physicians actually have plunged during the pandemic. Part of that was in the first year and even into the second year was nobody had time for it. They couldn't see the doctor. They didn't want to go to the doctor's office, but now we see it on the rise again. Disciplinary actions against doctors are also logged into a national database. That's the National Practitioners Data Bank. They have plunged. Claims have gone down. Everything went down during the first 2 years of COVID. What's going to happen in year 3, we're not sure. Some experts think the drop is a result of an acute shortage of healthcare workers rather than any improvement in quality. Critics say sweeping reforms. Despite that, the system is still designed to let problem physicians slip through the cracks. I want to show you from the California Medical Board website, the most recent data they have is through year 2020. And they don't have the data for 2021 online yet, but you can see how it went down. In 2018 to 19, they had 11,407 complaints received, and it went down to 10,868. I think that we're going to probably see it even went lower than that for 2021, but I think we're seeing now, the reason I know we're seeing an increase is because at the doctor's company, if you get a letter from the medical board, then our doctors send it to us and we help them with that response through our MediGuard coverage. And so that's very much increasing the number of calls we get on that. This I want to show you from the medical board website because it's license restrictions and suspensions. And this is for fiscal year 18, 19, and 19, 20. Again, 2021 is not yet available. And I wanted to show you that I think the numbers are actually pretty fairly low. If you look at sought and granted, self-abuse of drugs and alcohol, they sought 15 restrictions or suspensions and they granted 15. Under unprofessional conduct, they sought 17, but they only granted, the medical board only granted 10. So everybody doesn't get granted a suspension or some kind of sanction, fines, or penalty. However, sexual misconduct complaints against California doctors are up sharply. And sexual misconduct rose 62% since fall of 2017. And this is from a study at the end of 2019. And there is not a more recent study I looked to see. And so there was a big jump. But this also coincides, if you remember in the news, with all the Me Too litigation that we saw because the law changed. And so if somebody was sexual misconduct 20 years ago, I can now still bring a lawsuit against them. So in California, it's not the same in every state, but we do really think that the Me Too movement did a lot to push that up. So what does the medical board actually look at? I'm going to turn this over to Rich Cahill, and he's going to take us through what the medical board investigates. Rich?
Thank you, Kathleen. Good evening, everyone. My name is Richard Cahill. I'm Vice President and Associate General Counsel at the Doctors Company. I spent the last 35 years defending the medical community in a variety of civil and administrative litigation. For probably the first 10 or 15 years, the focus primarily in civil and administrative litigation involved professional liability claims, medical malpractice. But over the course of the last 10 or 15 years, the focus has shifted. First, it became issues having to do with managed care, and more recently with regulatory compliance. For example, issues involving EMTALA, the Cures Act, HIPAA, and most recently, Open Notes, the Cures Act of the 21st century. So what does the California Medical Board investigate? First, I should tell you that medical board is a state issue, not something of the federal government. That's pretty much by historical accident that the federal government was not involved in licensing of the profession starting in the late 19th century. And so each state has created its own Medical Practice Act, and California enforces that through the California Attorney General. So let's look first of all at what they investigate. The first category is complaints that are initiated ordinarily by the public, and Kathleen went through that with you on the one slide in which you go to the website and you could click on Make a Complaint. And there are 6 general categories. First, a complaint involving quality of care, in which the patient or patient's family alleges a misdiagnosis, that there was a treatment or medication error causing side effects, a surgical complication, negligent care, or so forth. Second type of complaint focuses on office practice, failure to sign a death certificate, failure to provide medical records. There's a specific California code section that requires that those be provided within a certain period of time, or misleading advertising, which can be brought as a result of the Business and Professions Code. I periodically get a complaint because a physician will be asked to sign a death certificate, and he or she will indicate that the practitioner has not seen the patient for some period of time. But they're the last person to have seen the patient, they're obligated to say something. Those are fairly easy to deal with, and I've never seen a problem in a physician actually doing the best of his or her professional judgment and trying to come up with something. Also, inappropriate prescribing, provider impairment. For example, as Kathleen mentioned, it's alleged that the provider is under the influence of drug or alcohol, creating a mental or physical impairment. Sexual misconduct, Kathleen's already gone through that in detailed activity. Also, unlicensed activities such as aiding and abetting an unlicensed practitioner or an unlicensed provider engaging in the practice of medicine. The second type of investigation that the medical board looks into are criminal actions. Well, how does the medical board learn of that? Well, first through the Department of Justice. If in one of their investigations they learn of something, then they will initiate it. Also, a physician must sua sponte report a criminal conviction on the license renewal form when that comes up. Also, a court clerk or a prosecutor is required to file a report with the central complaint unit in the event that is something that the prosecutor or the court clerk becomes aware of. I started my career as a deputy district attorney in California in the late 70s, and I never came across a circumstance in which there was any allegation against a physician. However, the reporting requirement existed in those days and is something that prosecutors must be mindful of. So what are the three most common causes for disciplinary action against a physician? And we'll go through these in subsequent slides in greater detail. The first is gross negligence. And what is that? An extreme departure from accepted standards of practice. The second is repeated negligent acts. These don't have to be gross negligence, simply negligent acts. And how is that defined? Well, under our jury instruction, the negligent act is the failure to engage in conduct consistent with the community standard. In other words, what would a similarly trained practitioner would have done under same or similar circumstances? And if it deviates from the standard of care, that is regarded as negligence. And third, incompetence. So let's look at those each in individual. First, gross negligence. That is defined as the extreme departure from accepted standards of practice. For example, not performing basic diagnostic tests, not using accepted effective treatments or diagnostic procedures, or not referring a patient to a specialist when, under the circumstances presented to the practitioner, that's something that would have been required. And finally, not recognizing common symptoms that would have required additional action taken by the practitioner. The second, repeated negligent acts. They are departures from the standard of care. Ordinarily, that's established by independent expert testimony. Someone is brought in to say, I'm familiar with the standard of care based upon my education, training, and experience. Frequently, at least when plaintiff's attorneys in malpractice cases present an expert, it's someone from an educational or academic setting. When I was doing it on behalf of Cigna, Kaiser, and Tenet hospitals, I found that community-based physicians were probably more effective because they dealt with the community standard every single day and were able to communicate what their understanding was very effectively to the finder of fact, whether it was a jury, a judge in the event of a bench trial, or an arbitrator in the case of arbitration. One act of simple negligence is ordinarily not enough to take action for this category of repeated negligent acts. Repeated negligent acts may be sufficient grounds for board action if, in looking at the practitioner's medical records, it is determined that there's a pattern of practice, and it may be a pattern of practice of a certain time. For example, not, ordering tests under certain circumstances, not referring to a specialist, and so forth. And the third is incompetence, and that's generally defined as lacking in knowledge or performing beyond training. I've had circumstances where a practitioner extends his routine practice beyond his area of competence. For example, last year I had a circumstance where a well-trained otolaryngologist was performing head and neck surgeries, and then over the course of time was doing additional types of plastic and cosmetic surgery, which included breast augmentations, tummy tucks, and various other procedures that were outside of his training and board certification. That became a problem because when it was raised to the level of a professional liability case, he was not able to say, well, I've had training in this. He simply said, well, I had an interest in it, and I began doing these procedures. So that's something that practitioners must be mindful of. That's also something that practitioners must be very careful when advertising, because the state of California in the Business and Professions Code has a specific section dealing with false and misleading advertising. Puffing or putting in qualifications or areas of expertise beyond the practitioner's actual training can be regarded as a violation of that. And I've seen it that somewhat clever plaintiff's attorneys don't file necessarily a claim for malpractice, although that might be a corollary. They'll claim that there was a violation of the false advertising section, in which case it's very difficult because it's not a question of standard of care. It's just simply a question that it was false advertising, and therefore plaintiffs' attorneys argue that the various protections created by the micro legislation, such as the cap, attorney's fees, notice, and so forth, do not apply. And that's, they also then attempt to get attorney's fees and so forth. So very dangerous to puff credentials on a website. Well, what are the causes for the disciplinary action? And Kathleen actually already went through those, but I'll just mention 6 or 7 of them very quickly. Sexual misconduct, conviction of a serious crime, especially involving something such as moral turpitude, substance abuse, and this is a serious problem, violating the drug laws or unlawful prescribing, which has become more apparent since the Cures Act of California involving utilization review was enacted about 5 years ago. Dishonesty, including filing false or fraudulent claims, and this is something that has been brought to the fore when the U.S. attorneys under the United States Department of Justice are bringing actions for violating the False Claim Act, also known as the Lincoln Law, for overbilling or upcoding and fraudulently recovering money for a CMS program. Illegal referrals, engaging in kickback schemes, or knowingly allowing an unlicensed person to practice medicine. Next slide, please. Romantic or sexual relationships. A physician must terminate the patient-physician relationship before initiating a dating, romantic, or sexual relationship with a patient. This is set forth in the AMA Code of Medical Ethics, section 9.1.1. Also, can you lose your license if you get a DUI? This is something that the medical board is very concerned about. Also, the abuse of other drugs, whether or not they're gateway drugs or otherwise. Physician could face severe consequences. If you fail to report, you can be sure that both the court clerk and either the city attorney or the district attorney prosecuting the case will report it to the complaint unit. And if you've had a conviction for this and you failed to report it, that will be a second count on the allegation against you by the medical board. Now, what do the possible consequences include? Fines, penalties, sanctions, public reprimand, probation, suspension, revocation, or even a demand to surrender your license. So what are some of the medical board triggers? The following will get the board's attention. Complaints made by the public through the website, settlements over the state reporting limit. Most of you are probably familiar that there's a reporting limit of more than $30,000 of a settlement. If there is a settlement in excess of that, or if there is a jury verdict or an arbitration award of any amount, even if it's under the $30,000 reporting limit, that's something that must be reported by the malpractice carrier. It's not open for discussion or debate. Also, 805 reports that may be made by disciplinary action. And if you're curious about this, I direct your attention to Google Business and Professions Code sections 800 et sec, in particular section 805, and that talks about the various triggers. Also, unfavorable media attention, and sometimes that happens. Not so much now as perhaps 20 years ago. Plaintiffs' attorneys would find it effective to, first of all, initiate some type of a board action before filing a malpractice action, and then if they were successful in getting some type of a sanction against the practitioner, then that would come into evidence at the time of the malpractice litigation. The next slide is simply an example of the type of letter that might be sent by the medical board, and I'll pause a moment and allow you an opportunity to take a look at it. This is part of the due process requirement of the United States Constitution, which says that you must be notified of the allegations against you as part of the due process. And the code section in the Business and Professions Code is 2220.08. And that's an opportunity that you have a right to be heard and so forth. So, procedurally, how do these complaints process through. First, you're notified through this letter that there's an investigation and that a written response is be required from you. Very importantly, you must or should report the matter to your malpractice carrier. If you're a TDC insured, we have something referred to as MediGuard. An experienced attorney in board investigations will be appointed, and the attorney will assist you and will prepare the response. Also obtain a copy of whatever the Department of Justice through the medical board has generated, and will work with you to prepare a proper response. Frequently, there are factual or medical inaccuracies in the report, and that's one of the first things that they'll focus on. There's only very limited discovery rights in these administrative proceedings, unlike in civil litigation, in which the Discovery Act of 1986 set forth extensive rights of litigants to do record requests, production of documents, written interrogatories, depositions, expert depositions, and so forth prior to the date of the trial or arbitration. Not so with medical board investigations. So what are the stages? The first stage is review. They get a complaint by one of the various sources or something from the district attorney's office or the court clerk. Then an internal investigation is conducted. Then some type of hearing is conducted in which the practitioner has an opportunity to confront and cross-examine witnesses at the time of the hearing and present evidence in his or her own behalf. And finally, a determination will be made by an administrative law judge as to whether or not the findings are true and whether or not any discipline should be imposed. It's key in defending your license, as Kathleen indicated earlier, that you get counsel at the various early opportunities. I've had calls over the years that I've been with the doctor's company, which has been since January of 2007, in which physicians say, I don't need an attorney. If I could just explain to the investigator what happened, I'm sure the investigator will simply dismiss the charges. That's not the case. That's simply not going to happen. It's an adversarial proceeding. The investigator and the medical board is not on your side in this thing, and they will attempt to get information supporting their view of the case. And so simply trying to explain to them what they perceive to be the case will not be helpful. So you have to focus on the board's expert, find all errors, both in their pleadings document that were factually or medically incorrect. They will also have allegations that will be based on those facts, and those can therefore be would be refuted. There also may be venue issues. Well, what is venue? Well, you have a right to have the case tried in a certain jurisdiction. For example, ordinarily it's done in the jurisdiction where you practice or the alleged malpractice or other conduct occurred. So if they allege that the conduct occurred in San Diego, but they file the proceeding in Sacramento, your attorney will move to change venue so that it's a more convenient forum for you in San Diego. Also, it's important that you actively participate in preparing the defense. Yes, it's frustrating. Yes, it's emotionally very taxing to have to deal with this, like it is with all civil litigation, including professional liability claims, but you need to be actively engaged so you understand what's going on. The vast majority of these cases are resolved in favor of the practitioner, and that is necessary, therefore, for you to be actively involved. It's also important that you appear in person, and that's one of the requirements that we always tell physicians in the event of a trial or arbitration. It's key that you be present to show your interest and also so that you can assist your attorney as the evidence is coming in to make sure that you can address issues as to factual accuracy. So what's the defense response? The attorney prepares the response for you in conjunction with meetings that you have. It's done on the attorney's letterhead. It's written and signed by the attorney. 90% of matters are closed at this level. Once the attorney prepares a response, points out the relevant passages of the medical records, the board closes their file. I've had frequently physicians ask, well, how can they get the medical records? Do they need a subpoena? Do they need to have the patient actually authorize it? You might recall under HIPAA that there is an exception to a requirement of patient authorization in the event it's a government oversight agency. Both the Department of Justice and the medical board would be able to get the records simply by writing to you, sending you a letter and saying, we hereby request pursuant to the applicable HIPAA section or California Civil Code Section 56, which is the California Confidentiality of Medical Information Act. This is crucial. During the pendency of this, never discuss or meet with the medical board investigator. They will say, we just have a few questions for you. And I've had a couple of cases involving allegations of professional negligence in which I had no knowledge that there'd been a medical board investigation. The physician had not brought it to my attention. And the plaintiff's attorney, because he or she represented the patient, was able to get a copy of the file, then brought it into the trial or arbitration, made it very difficult to defend against that. Also, do not discuss it with colleagues or friends. There'll be a huge tendency to want to do that. I had a trial many years ago with Dr. Bruce Fagel, and the case started in January of that year. It was a 10-week jury trial out in San Bernardino, and somehow he got wind that this is, and it was a delivery that occurred in the 1960s of all things, but because it was involved a minor, one that went to trial in the mid-80s, most of the practitioners were now at the end of their career. Somehow Dr. Fagel found out that the practitioners had been at a gathering, actually a Super Bowl party. Some testified before the Super Bowl, some testified afterwards. And so everyone that testified after the party was asked the question, did you attend this gathering? And did you all discuss it at the time of the game? And of course, when they all admitted that they had, he was able to turn it into some type of a conspiracy in which the doctors were trying to get together, which was not the case at all. It was just a casual conversation during the course of a social gathering. But it was effective with the way he did it. Make sure that when you have any meetings, procedural or substantive, with the medical board or investigators, your counsel needs to be present to protect your rights. He or she will do all of the talking and will make sure that you understand what the proceedings are. As Kathleen indicated, the board is making concerted efforts to educate the public as to what the public's rights are with regard to the medical board. Senate Bill 425 went into effect January of last year, in large measure as a result of the Me Too movement. It assures that allegations of sexual abuse and misconduct are reported to the appropriate licensing boards. In your case, for the most part, it would be the Medical Board of California. The reports are confidential and are protected from disclosure.
Rich, we're going to turn it over to Keith at this point on 805.8 reporting.
Okay, well, that sounds real good. Thank you very much.
Thank you, Rich. Keith, you want to tell us about 805.8 reporting, please?
Will, thank you, Rich and Kathleen. The relatively new Business Professions Code 805.8, it's actually now just over 2 years old. And we want to go through this evening a little bit of the background and how you understand what is required and the consequences for non-compliance. The purpose of this was to make sure that allegations of sexual abuse and misconduct do get reported to the proper agency in California. The reports themselves of the complaints are confidential. They're protected from discovery in civil litigation. But if an administrative action, the type which Rich was just describing, goes forward, then the 805.8 report is discoverable against the practitioner there. And there's not a civil or criminal penalty if you were to file one, especially, if it was shown to be incorrect or there was no veracity to the complaint, that you're not harmed for bringing it. So I want to take a look at the specific language of the code. There's some interesting components to this. Generally, what you need to recognize is that it is very broadly defined, and so there's not a lot of loopholes. There is one interesting area that requires some thought on your part, but for the most part, it's very broadly defined. So let's take a look at it. A healthcare facility or other entity that makes any arrangement under which the licensee is allowed to practice shall file a report of any allegation of sexual abuse or sexual misconduct made against a licensee by a patient or that patient's representative, as long as it's in writing. And they have to file that within 15 days of receiving the written allegation of sexual abuse or sexual misconduct. So it's a very broad net, a healthcare facility or other entity, any licensee on a report. Now, the arrangement that they're talking about, you'll see in the second paragraph, again, it encompasses basically everything there. So you don't need to spend much time wondering, do we have a healthcare facility? Do we have an arrangement where a licensee is providing care for patients? It's most likely any professional setting does. Even you can see locum tenens on there, so it could be very minor provision. So everybody's really covered by this. And then the types of licensees that are covered, it's also very, very broad. So it's not just MDs and DOs. You can see the list. It includes your nurses and dentists and chiropractors and PT and massage therapists and on it goes. So very, very broad on the obligation of reporting on if you have any type of licensee really practicing any type of healing arts in any type of facility. So it's the takeaway lesson there is that it's a very broad reporting requirement, even for a small practice with maybe only one other licensee working there. The obligation flows from, though, a written allegation of sexual abuse or misconduct by one of two sources. It's the patient or the patient's representative. Okay, but if it's not in writing, now we're that's really the only one that would cause you to not file the report with the proper agency. You're also on a pretty quick timeline. So as soon as you get something in writing, you have to figure out, is it from the patient? Is it or a representative? Does it allege sexual misconduct? And if not, if so, then 15 days and you've got your report up to the proper agency. Now, your discretion here, if it's a vague reference, things like I felt uncomfortable, it was an awkward encounter. There can be times where that could be sexual misconduct, but it might be just a social awkwardness and it's unclear, but it was in writing. So in that regard, it does behoove you to report it to be safe rather than sorry. All right, we can see the next one. And the next slide. There we are. Why is that? Because any failure to file the report is punishable by a fine of up to $50,000 each time there's a failure. Secondly, if you willfully don't report it, and then it's a $100,000 fine. So it's a very, very stiff penalty for not reporting. And as I mentioned at the beginning, there is no criminal or civil liability for doing the report. So all of the incentives point in the direction of making sure you get the report filed on time. Where do they go? Each board has a website. As you know, the medical board website is the first there, but they all have a site where you can get the form, and it's listed here. It's in the PowerPoint packet, but you can also find it on all of the board's websites under enforcement or complaint 805.8, what have you. You'll go under their form section and find the appropriate listing. make sure you do that within 15 days. All right, so with that, I want to bring on my law partner, Lil Del Campo, to kind of walk you through the decision tree on is it time to make a report or not. So Lil, you go ahead and take it away. Thanks, everybody.
Thanks, Keith. So I want to dive now a little more detail, some of the things that Keith was just talking about. And it helps to break down the thought process. So as he went over the statute, any healthcare basically any healthcare facility or entity, that means a medical group, an office, even a solo practitioner, has an obligation to report. The first thought in the triage process is how was the complaint made? Because if the complaint is a phone call or an in-person conversation, then you don't have to report it. You only have to report if the complaint is in writing. Of course, that means an email, it could be a letter, it could come in various ways, but if it's in writing, then we're in the yes, then the statutory requirement is met and we go on to the next step. So you do not have an obligation to notify the patient if the complaint is made verbally. So there's no requirement that you say when a patient tells you, I have this complaint, well, why don't you write it down and send it in? Some providers have that as a policy. So there are practice where if a patient makes a verbal complaint, they request for it in writing. If that is your practice and policy, I would not treat these any differently. And so you will be putting yourself in the situation of having to solicit something that you're going to have to report. So, you might want to assess if that's what you want to do or not. Okay. What did the complaint allege, right? So once you have it in writing, now we need to do the next sort of triage assessment, which is, does it include sexual abuse, sexual misconduct, inappropriate contact, or communication of a sexual nature? So as Keith was saying, very broad on purpose. The ones that are pretty vague are, of course, inappropriate contact or communication of a sexual nature. If it falls into any one of those broad categories, then you're going to have, then we would go on to the next step because the statutory requirement is met. So as you are trying to decide whether you've met the statutory requirement, this is where we have some examples, right? Obviously there's going to be some things that are reportable. You'll know it right away. But there will be some moments like what Keith was describing where I felt really uncomfortable. That was really out of the norm. Those are going to be a little more difficult, possibly would not fall under the statute. But as Keith was saying, you would probably want to report it anyway, assuming it was in writing and you got to this step of the analysis. The ones that I feel the jokes are things that were supposed to be funny and aren't, is probably one where I've seen to be the trickiest. And I think that our advice is usually err on the side of reporting. So let's see, so in terms of, as you're sitting here going through the thought process, you've now got a complaint in writing from a patient, you think it falls under one of the categories. I have had it where some providers are thinking, well, maybe this doesn't cover us, or maybe it doesn't apply to my kind of, I'm a solo practitioner. I'm just one person, one provider. And reiterating that this statute is supposed to be broad. I think if you are providing healthcare, you're probably covered. But here are some of the examples of the facilities and entities, right? And the ones that I think have caught some people off guard is the massage therapy practice, but also physical therapy, occupational therapy. Those are all covered. All right, so then our next step is the complaint, because the statute does say it has to be the patient or the authorized representative of the patient. The authorized representative of the patient is a technical legal term. And so you can assess that, is it the patient or the authorized representative? If it is not, then the requirement is not met and you do not have to report. But if it's directly from the patient or through the patient's authorized representative, then the statutory requirement is met also. And you have to report. So that pretty much takes you through the analysis of the key things to be thinking about on when to report. So on the other side of this, if you're in a group practice or you're practicing in a facility, and obviously we've had a lot of changes in the last few years around sexual misconduct policies. I do often get questions about, well, what should we be thinking about, or how should we be addressing some of this now that, the medical board is very interested in knowing about sexual misconduct complaints and will be looking at them. So these are some of the ideas and strategies to be thinking of. I think one of the ones that I've seen most implemented is we've had the medical chaperone policies for OBGYN and certain kinds of exams for a very long time. But there are other ones where they have not been done that you might want to start considering doing, or you're seeing recently in facilities that they've been requiring. But things like, skin, if you're a dermatologist and you're going to do a skin check, if you're family practice or internal medicine, and you're going to do an examination, you might want to have a chaperone with you. So those are some of around the medical chaperone area, expanding the types of exams that you have chaperones. Now, I do get questions periodically, well, we don't have the resources to have a chaperone in every single exam. Understood. And that's where there will just have to be some decision making about, well, these kinds of exams are the ones where we are going to have a chaperone. The other ideas, strategies is you do want your workforce. Most workforces are required for supervisors to do sexual harassment prevention and training, and now it's for non-supervisory workers. That helps start a conversation within your organization or your office practice of what are the kinds of things to be looking out for that are not tolerable, which then also the zero tolerance harassment policy, and making sure that other licensees in your office or your co-workers are aware that, this conduct will be reported. And so it is important to have a clear policy on the zero tolerance and how you will take action against someone who may be crossing those lines. And the potential repercussions of a complaint and a board investigation are really all of the things you've heard about tonight. So you want to be cognizant of the fact that, Kathleen was mentioning the increase in complaints on sexual misconduct. And Rich was covering all the times that you want to make sure you have your counsel with you. So if you have a situation where you're the subject of one of these complaints, that is exactly when you want to start reaching out and getting some counsel and figuring out how you're going to respond. We've had a couple in the last 2 years in our practice where it appears that it was an honest miscommunication, that the physician said something, did something that the patient misunderstood. And so those types are where I see the most vulnerability, because there is just a lot of room for a patient to believe something went wrong, was done inappropriately, with a potential sexual overtone because it possibly was a sensitive exam. So one final thought that isn't on this slide, though, that I've been seeing some clients implement that seem to be doing better, is educating patients, so ahead of the exam. So if we're having a skin check exam, some sensitive exam, then a checklist ahead of time of what they can expect to be happening may be something you want to consider doing in your practice. And next.
Okay, there we go. Hey, Will, before you take off and we move to Kathleen, there's a question in the Q&A that I think is directly from 8058. Can you pull that up, or would you like me to read it?
Let's see. Why don't you read it?
So in the setting of a group practice, if a physician receives a written complaint appropriate for 8058 reporting, is the medical group as the entity responsible for making the report, as opposed to the individual physician who is accused? This presumes that there's a policy that requires the physician to immediately report such complaints to management. Trying to make the distinction between individual physicians in our group who are on this webinar, this is a group leader I know, making the 8058 report versus informing the medical group who will be responsible for the report.
Yeah, so great question. The statute says it's the entity's responsibility. So the facility or the entity have to be, are supposed to report. So that, back to kind of the policies. So you should absolutely have in the zero tolerance harassment policy, a reporting policy where people should report to management. It is the entity that should report. What we don't know, because we haven't seen it happen, it's still, I think, pretty recent, 2 years in, is if the medical board finds out that a physician knew about this and it happened in their group practice and the entity did not report, I don't think it's out of the realm of the possibility for them to take the position that there was a professional responsibility to report anyway. So what I have, couple of times this has come up, is I have advised the individual physicians to make sure that the leaders, that management and leadership have reported it.
And Paul,
yeah,
I don't know if the group can hear me, just to add to what Lil is saying. In any multi-physician setting, it's probably best to have a designee where everything funnels to. The statute speaks about the designated individual. There's not language in the statute as to what happens to the designated individual if they didn't, but the group would certainly be penalized. But the group wants to take the step of making a designee so that everybody knows where to hand in any written complaints of any nature and let the designee make the decision. And also the designee then has the burden of making sure that report gets filed.
That makes a lot of sense. While I have the two of you here, there was a few questions earlier in the chat. Some of them might be rich, but I'm sure you can probably help handle these. So I'm going to go through this real quick. If a malpractice suit is filed, is the complaint automatically sent to the medical board?
You have a reporting obligation if there's a resolution. Rich talked about this at $30,000 or higher, but that doesn't generate an automatic report.
This might be a little more difficult. What happens?
Let me take that a level deeper than the question's actually asking.
Yeah.
The plaintiff's attorney, or even the patient, or many times the patient's family, can, at a very, very low cost to themselves, file the same complaint that they might be suing you. And you can do that to make the doctor's life very difficult, because now they're defending themselves on two fronts. One, they've got a medical board action investigation happening that Rich described in detail, and the other is they've got a lawsuit going on. So it is not that it has to happen, but it could be happening for tactical reasons by the plaintiff's attorney or the patient or the family. A lot of times patients will complain, not get the resolution they want, and then go to lawsuit. You know, it really can go a lot of different ways. But you have to get the report in if you resolve it for over 30,000.
What happens when a provider refuses to prescribe unapproved COVID meds to a patient who wants them?
Absolutely nothing. And no one would have any way of knowing this yet, unless Lil's heard of something that's in the breaking news category.
Well, I think what I see here is if the patient is upset and then they file a complaint, I guess I would presume the medical board would dismiss that pretty.
The normal legal thing that we look to there, a legal term, is the community standard, right? The standard of care in that community. Lil might disagree with me, but I think we're still relatively early on in COVID to have a totally defined on that, because you need an expert who can say this is the only way this community would treat it. I think we're still in the wild west of COVID treatment, to be honest with you. There's a lot of things still to be learned and tried. I think there could be stuff that was below the standard of care, but an unapproved med, that would be hard. That would be hard to envision that someone would be disciplined for basically not doing what their patient told them to do at this stage in the game. Lil, did I cover that one? Is that you share that view?
Yeah, although I'd be interested to see what Rich thinks.
I agree completely. The issue is always standard of care. And, an unapproved treatment would not be standard of care. So I think that Keith fully covered that. And that's the type of thing, I think, if the board were to look at that, depending upon how the complaint was phrased, it may not even rise to the level where the physician would be contacted. Look at that and say, this is a totally frivolous complaint. The investigation would have consisted of reading what the patient wrote, and then in the event that they wanted, a further response, they would correspond with the physician. And then, of course, you'd contact your malpractice carrier, attorney would be appointed, and a brief response would be this. We generally don't rely on patients to tell us what the approved treatment course is, and this certainly wasn't an approved course of treatment recognized by the CDC, the community standard, or anyone else.
Okay. Another one in the chat, and I think this was before the 805. Is there an obligation to report if a complaint is filed by a coworker? Not more detail than that. I think this was during Rich's, but I really don't have context. I don't know if any of you guys do.
Yeah, that one depends on what and when, I guess. There can be 805. Well, as you saw from Lil's breakdown, there's probably not under 805.8 because it was filed by a coworker. If it was filed by a coworker's patient, then the answer would be yes. But it's patient or patient representative, as we covered on the 805.8. In terms of other types of issues, is there an obligation? We'd have to jump back to Rich or Lil on that one. I don't know, but I don't think there would be on 805.8.
Yeah, I think this came out before 805.8. This came out during Rich's part.
Yeah, I guess if a complaint is filed by a coworker, I mean that I guess we'd have to know what that complaint is. There's a lot of employment related complaints that don't trigger a report to the medical board. So I guess, and I can't think of a coworker complaint that necessarily triggers a report to the medical board. So it's probably not, but it depends on what that complaint might be, would be the safe answer.
And my final one that just came in. How often does the medical board hold employed physicians responsible for negligence by staff? E.g., if the physician asked staff to call patient with info or to make an appointment and they did not, or if request was sent to records department and not fulfilled.
In my experience, where I haven't seen it, that one sort of sounded like an allusion to a patient abandonment problem. I haven't seen that particular case. The one I have seen many times many times, unfortunately, is the billing clerk billing, whether outsourced to an independent contractor or inside the practice, billing errors are made, and the doctor's response is, well, I don't know codes, I don't do billing, and so that's my billing person. Well, the billing person is your agent, and they are not licensed by the board. The board is not coming after your agent. They're coming after you for what your agent did. So there very, very much is in the realm of billing, this liability that could flow to your license from one of your workers. There are, I am sure, other areas where that could apply, but I know from a number of cases that where it applies in the billing context for practices. So you do have to be aware and constantly training. And as Lil pointed out, you need to be training people too on sexual harassment and the like, not just for medical board reasons, but also for, professionalism in the practice reasons, but also lawsuit reasons.
Okay, we're popping up some more. Actually, I'm going to go to Kathleen, and I can read these. Kathleen, you're muted right now. Do you want to come finish off the slides?
Mute. Okay,
There
I'm
we go.
muted.
Yes.
I don't know, I lost my slides, but I wanted to make a couple comments before I bring the slides back up about this conversation, because the kinds of complaints we see where the medical board gets a report from a consumer is a retaliation against staff who won't make an appointment or has some kind of excuse. So we see a lot of those complaints. So I just want to say, yes, we do see a lot of medical board complaints that are motivated by staff behavior. And because the medical board doesn't care about your staff, they're agents of your practice, they do come after you. But one of the things that I want to bring up also is that the medical board during COVID, they have been more, can I say, discretionary about approaching physicians. But before COVID, I would always get calls from a physician said I was walking back from the parking lot and some man walked up to me and said, "Are you Dr. So-and-so?" "Yes, I'm an investigator with California Medical Board. I need to talk to you." And the doctor said, "Well, I don't want to talk out here in the sidewalk. Let's go in my office." And while I don't see them doing that now during COVID, what they do is they call and they get the cell phone number for physicians. I've lost count of how many doctors have called me and said, I answered my cell phone and it said, "This is agent so-and-so with the medical board. I need to talk to you about a complaint." Doctor hasn't even seen the complaint. And I just want to implore to you, do not talk to anyone on the phone. If they approach you to say, "I'm sorry, if you have any questions, send me a letter in writing and my attorney will respond." I'm talking hundreds of calls a year I get like this, that the physician is approached in person at their home. I had one that was approached at the market. So this is still happening. The other thing I want to say about the 805.8 reporting that's been very frustrating for physicians is it says that you must respond within 15 days of receipt of the letter. Here becomes the problem. Your office staff gets a stack of mail and they don't open it for a week. And then it says personal to you, so they don't open it. They put it on your desk and it's on the bottom of a pile and it's 3 weeks later that you open it. I think it's like getting a letter from the IRS. You know, if something is a personal letter to you, if your staff isn't going to open it, you need to prioritize opening it, and it should be date stamped when it arrives. We've also had people say they sent a letter and there's no evidence. And I had one doctor that actually, he said, "I heard you say that we should keep the envelope." And the postmark for the letter was in fact within the 15-day period. And the doctor did respond within 15 days, but he said he mailed it earlier. Fortunately, they had saved the envelope, so they had the postmark. So those are some things that we've seen with the 805. That again has been retaliatory. We have had cases where an employee is a patient of a physician And then they either get let go. We saw this a lot during COVID, and they had to thin staff, and they retaliated with a 805.8 complaint, knowing that they could cause trouble for the doctor. It was very obvious. Most of my groups, they do have the office manager or the entity person is designated to the form, but it's very important. Remember what Rich said. If you don't do it timely, it's a $50,000 fine. And if it's willful, it's a $100,000 fine. So you really want to be timely when you turn that in. Now what I'm going to do is go back to get my slides up. And we do still have some time for questions. Can you see the slides?
Yep,
They're there?
they're there.
Okay, I'm going to go to the end. The California Medical Board designated California Medical Association to write the standards for a new law that took effect January 1, 2022. And this has to do with cultural, linguistic, competency, and implicit bias. And their position was that there is implicit bias in healthcare with people. We all have our own biases about things. And I shared an example in a story that I'll share as I'm trying to get to the right file. I was sick on the weekend of New Year's, and then I called my doctor, and he called and prescribed medication for me. And the first thing he said was, I want you to take this because I know you never take medication I prescribe. And I said, why would you say that? And he said, because when I saw you in October, I prescribed blank, and you were supposed to stay on it for 90 days, and the pharmacy has called me that you haven't refilled it. I said, yeah, and I never finished the third. He said, see, you're not a good patient following my instructions. You're non-compliant. I said, I admit it, I am. But so he knows, he knows that about me, and that's fine. We do all have our own internal value systems. I want to just explain to you that the effective January 1, we have another California Business and Professions Code change, Code 2190.1, that any accredited CME program must meet standards for inclusion of cultural linguistic competence and implicit bias. The standards were developed by the California Medical Association at the direction of the California Medical Board. So the doctor's company can only give this credit tonight if we included something. And to be honest, I wasn't really sure what to include, but what I made up passed. So here you go. The definition of cultural linguistic competency, and I'm going to call it CLC, is the ability and readiness of healthcare providers and organizations to humbly and respectfully demonstrate, effectively communicate, and tailor delivery of care to patients with diverse values, beliefs, identities, and behaviors in order to meet social, cultural, and linguistic needs as they relate to patient health. The definition they wrote for implicit bias is the attitudes, stereotypes, feelings, whether positive or negative, that affect our understanding, actions, and decisions without conscious knowledge or control. Implicit bias is a universal phenomenon. When negative, implicit bias also often contributes to unequal treatment and disparities in diagnosis, treatment decisions, levels of care, and healthcare outcomes of people based on race, ethnicity, gender, identity, sexual orientation, age, disability, and other characteristics. Given those definitions, individual personal cultures and systems of beliefs also impact an individual's acceptance of healthcare measures, treatment, and medications, and how they perceive and what their willingness is to participate. Respect cultural impact for staff and patients. And you notice I added staff in there because in the Business and Professions Code, it doesn't just mention patients, it also mentions staff. That you are sensitive and aware of this list: education, race, sexual orientation, gender identity, religion, income was on there, and ethnicity. There was a comment made during the 805.8 discussion that had to be with lewd comment or a sexual innuendo or a joke. Well, I think we've all learned over the last several years that there is no place in business with the staff or with our patients to make any jokes or snide comments because we don't know that it's appropriate for anyone. Well, it's just like employees, and that's why it's so important that they get this sexual harassment training referenced by Keith and Lil, because if I work in your office and somebody tells a dirty joke to my neighbor in the office and they think it's hilarious and I'm offended, I have the right to bring a lawsuit against my employer for that because it was offensive to me. So even if it wasn't there, if I was in the room and I heard it, and they said, well, I was whispering it. You, Kathleen, couldn't have heard it. I said, I heard it. And you can have a lawsuit on your hands. The other thing that in this bias and CLC discussion that I found that was of value to share today was recognize the culture of your staff and the culture of your patients influences communications. This isn't just their language. It's really about their health literacy. They might be able to speak English, but do they read English? They might read English, but is it their first language? Are they able to compute the health literacy of what you're telling them? We have many people who are very highly educated who have low health literacy. And of course, you want to also incorporate support values for effective staff and patient communications. What are support values in the standards that CMA wrote? It includes compassion, empathy, curiosity, tell me more, concern. I'm concerned about how you're feeling. I'm concerned about what you're saying. I'm concerned that you waited so long to come to the office. Respect for people's decision. And one thing to say is think about using that word. I respect your opinion. I respect your decision to not participate in this aspect of the care. But I'm really concerned, and maybe I would like to have you go to a doctor and get a second opinion. So maybe I'm missing something and it would be helpful if you talk to another physician. Using the second opinion strategy can be helpful. You must recognize health literacy and or language barriers. Using a translator when necessary. And I just want to tell you, please do not use family to translate. Everyone has access to a translator through the AT&T language line. If you're in the hospital, they have people who can translate. I had a situation where the doctor stepped out from a visit with a patient and said, I want to know what to do. I'm a fertility specialist. The man brought his wife, said she speaks no English and he wants to translate, and I don't have anyone in the office that translates. So he was translating. And I was telling her, I think that she could get pregnant and these are the things we can do. And then my MA was in the office and she handed me a written note. And I read it and it said, would you please step out of the office with me? And they did. And she spoke Farsi, but she didn't want to be the translator. So she just said, I don't do that. And in the hallway, she said to the doctor, I do speak Farsi. And I want you to tell you everything you're telling the husband, he's telling the wife the opposite. He's telling her there's no way you'll ever get pregnant. There's nothing that can be done. We've exhausted every avenue. And the woman had started crying, sobbing. And then he said, okay, will you go in and tell him I have an emergency? And he called me. And I said, well, go in and tell him the truth. My medical assistant speaks Farsi. And she tells me that you have been telling your wife the opposite of everything that I say. And he had the medical assistant tell the patient that. And the patient just froze. And the man started screaming and dragged his wife off the table, pulled her pants up on her, and stormed out of the office. Family should not be the translator. You have no way to know what they're saying. And you must also always document a translator with in the medical record. If it's your staff, if it was your MA, you could say MA, KS translator. And in fact, the MA can translate the self, MA translator. The other area that came up also in the 805 discussion was a chaperone. And I know it's hard when you have a small office and you have skeleton staff right now during COVID in many offices. Every day I get a call from someone that says, I don't have anybody to be a chaperone. Okay, then who's in there? Well, I have, they brought a guest or a family member. So then you need to explain to them, we can't do part of the exam without a personal chaperone, and we do not accept family or guests for chaperone. So right now I don't have anyone for chaperone. I'm either going to have to forego this, or you're going to have to wait a bit. And as soon as my MA is free, she will come in and you don't stay in for the whole visit, just come in. You can go get your receptionist and say, I need you to come in for 2 minutes for this part of the exam, and then document someone was there. So that's really important that you document the presence of a chaperone. I'm going to close with my Dalai Lama quote that I love: do not let the behavior of others destroy your inner peace. This is really important right now. You've been in a battle for over 2 years with COVID in this pandemic, but you still show up and you still provide. And I know you give compassionate, empathetic care, and you do care about your patients. That's why you're still there. You're here tonight because you want to know how to avoid a letter from the medical board. I hope that we've shared some strategies with you. Most importantly, I want you to hear as a takeaway, do not speak to anyone from the medical board ever. Just say, I'm sorry, on the advice of my malpractice insurance, I cannot speak to the medical board. I have to have my attorney, and I need a letter in writing. You can fax it to me and I will get it right to my attorney. And so with that, I think we still have 7 minutes left. Paul, I'm going to turn it back to you and ask if anybody has any questions.
Great. I'm going to bring everybody up here. I'm going to end the screen share for right now. Let's see, no. And go. Yeah, there's a few. First quick one. Can a scribe be a chaperone?
I'm sorry, what?
Can a scribe be a chaperone?
Yes, absolutely.
That's what I thought.
Document scribe was chaperone.
Yep.
Perfect.
In the ER, not infrequently, we have a patient who is verbally aggressive to staff, at times threatening. Then they go report the doctor or nurse to their respective boards for not taking care of them. Usually this occurs when security arrives and they're invited to leave with an escort. How can we avoid these nuisance complaints?
You have to have really good documentation, and we didn't go into that in this session tonight. But when you get an inquiry from the medical board, the letter will say, please respond to this complaint within 30 days of the date of this letter. Please include any documentation to support your response. So you're going to have the letter or a medical record, a note. If the patient was a medical record, then it should be said, what did that disruptive, abusive patient say? I'll give you an example because I do a training on this. So you tell the patient, well, the doctor is going to see you, but he's going to be about a 20 to 30 minute wait. And somebody gets really upset and says, what's the matter with you people? What kind of hospital is this that I have to be waiting? Or you're just a bunch of idiots. What do you do with that? In the note, it says patient advised, physician will be delayed for 20 to 30 minutes. Patient responded, in quotation marks. What's wrong with you people? Are you a bunch of idiots? You just take the worst part of what they said. If they drop the F-bomb on it, then you put that in there. And this patient said blank, and you put it in quotes, because having the patient's words in that voice, and I'm going to ask Rich to chime in on this. Rich, what does that do when the regulatory agency or in a litigation, they see that language in those comments in quotes from the patient? How will that help the doctor? Rich, are you still there?
I can jump in on that, Kathleen, while Rich is logging in. Yeah. What Kathleen said about documentation and record keeping is the kind of end all be all of these board defense matters. And if it's not written down, it didn't happen. So documenting it, so I 100% agree with what she said, because then we can let the investigator come to our conclusion rather than trying to convince them and have it be a he said, she said. If you have a contemporaneous written instrument on it, then they can see what was happening. And in an ER setting, they're not going to be the only person there. So now we have witnesses too. The question, though, does also say, how do we avoid these nuisance complaints? And unfortunately, I think the answer is you can't, other than just continually improving, trying to head off an escalating situation. But the reality is those situations happen, and they're going to happen. When they do, make sure they're documented, make sure you've got a witness for what's going on. I think it was Rich's slide earlier pointing out something that I would note from my own experience, which is 90% of these investigations disappear before going anywhere. And so those ER nuisance ones, they really are, to Kathleen's earlier point, have your lawyer put a response on legal letterhead and have that submitted. The investigator, if it's written well, will understand what's going on and say thank you, and then that will be dismissed and disregarded. Completely avoiding them, very, very difficult. The state has an obligation to investigate everything that's sent in, and they've got a website for people to send it in for free. There's no downside on an angry patient reporting, unfortunately.
And Keith, like incidents like that, anything like that, the advice of making documentation, keeping that's outside of medicine. I mean, I do that in my office when we have, people complain about our advocacy or something like that. In life in general, if you having records and documenting it in advance, I send myself an email so it's date stamped. Will help you a lot.
And and as Kathleen knows, something, if your audience is interested, we can talk about that practice wide, not merely a medical board setting, because where this kicks up a lot is all your employees. And as a lawyer who represents the doctors on the defense of, let's say, an employment lawsuit, not just a medical board one, if all of a sudden I've got a ton of documentation the day before you fire them, it's not as useful as if I have a slow, steady stream of this person's really not performing. So we can talk about that at another seminar if people are interested. But you can't avoid a nuisance complaint with the medical board. You can defend yourself and have it knocked down before it becomes a headache in your life.
Okay, let's see which ones more I can get here.
I want to add a point about in the office practice setting. What I find that is least frequently documented is the rude, inappropriate, disruptive patient on the phone, because these patients do not generally act out in front of the doctor. They do it on the phone to your staff, and you must train your staff that if someone calls on the phone and throws a rash of inappropriate and dirty words and comments on them, the last thing we want to see in the record is patient was rude and used inappropriate language or used foul language. That does you no good. You need patient called, requested appointment, told doctor was not available, offered PA or NP or urgent care. Patient raised his voice and said, in quotes, "You're a bunch of blank, 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 and I don't even know how you got a job. Did you even go to school?" And then, the response, and the response that we train our staff in our doctor's company practices is, "I'm sorry, we have a zero tolerance for that kind of language and behavior. I'd really like to stay on the phone and help you, but if you continue and use that language, I won't be able to stay on the phone." And sometimes people calm down. Other times people throw a very dirty remark in their face and hang up on them. You need to capture that in the medical record, because that is exactly what will be part of the documentation that will go with the response to the medical board and also with a grievance to the health plan. So if you would like training for your staff and you're with the doctor's company, we provide that. And it might be a great topic. We have a new program, Paul, that we're just rolling out in February, and it's called Best Practice Documenting Disruptive Patient Behavior. So that's a CME that you might have an interest in the future. I want to remind you, if you want CME credit, that you can put your smartphone on the QR code on this slide, and you can register if you need any assistance. The phone number and my assistant, Julianne Miles, her email address is there, and she can help you. Thank you so much for inviting us tonight. I really want to thank Keith and Lil. You were amazing. Rich sent me a text that he got disconnected and he did not call back in. And thank you, Jen and Paul, and for all of the attendees tonight. We wish you well, and we hope you stay healthy and that you don't have any issues with the medical board.